Well, good evening for those here in Geneva, and good morning, good afternoon for those who are joining us online from different parts of the world. Our warm welcome to you all to this event, From Surveillance to Empowerment, Advancing the Responsible Use of Technology in Alternatives to Detention. My name is Carolina Hernandez. I speak on behalf of the Office of the UN High Commissioner for Human Rights, OHCHR, where I serve as OHCHR's advisor on migration and human rights and coordinator of the work that we do on the human rights of people on the move. So from a human rights perspective, today we have a critical conversation. Digital technologies, as you all know, are increasingly shaping migration and border governance with real impacts on the rights and dignity of refugees and migrants. And when used with clear rules and safeguards, they hold the potential to support safer and more human migration. But without those safeguards, oversight and accountability, they can just as easily undermine dignity, restrict liberty, deepen discrimination, and expose migrants and refugees to human rights violations and abuses. That is why our office, OHCHR, is actively engaging on this issue, including through research and consultation that we've been advancing on guidance on the human rights compliant use of digital technologies in border governance. But of course, I won't be going into that today, because today this event is about launching and discussing the pioneer new report produced by the Kaldor Center for International Refugee Law, the International Detention Coalition, and the Refugee Law Lab. We have a QR code here, and we will be adding the link we have already to our chat, so inviting you all to please download the report. We are very fortunate to have with us the 4 co-authors of the report, who I am pleased to introduce, and will present the findings and the recommendations in the following order. We have with us Carolina Gotardo, who's the Executive Director of the International Detention Coalition, a global network with members in over 75 countries advocating against immigration detention and promoting alternatives. Carolina brings over 2 decades of experience on human rights, migration, and gender. She has led organizations, including the Latin American Women's Rights Service in the UK and the Jesuit Refugee Service in Australia. She also serves on the boards of the Women in Migration Network and the Asia Pacific Refugee Rights Network. Then we will hear from Daniel Gesselbach. Daniel is a professor and director of the Kaldor Center for International Refugee Law at UNSW Sydney. He's an internationally recognized scholar of refugee and migration law, legal technology, and access to justice. And he's the co-founder of the Hear Me Out, one of the first AI-powered legal tools designed to help people challenge discrimination. We will then hear from Antonella Napolitano, who is IDC's research consultant on digital technologies. She's a tech policy expert working at the intersection of technology and human rights, with research focusing on migration, welfare, and reproductive rights. Her previous work includes studies on digital identity and on AI in migration governance, and she has previously worked at Privacy International, where she developed a global program on migration and technology threats. And last but not least, we will hear from Petra Molnar, a lawyer and anthropologist, who is the Associate Director of the Refugee Law Lab at York University, where she leads the Migration Technology Monitoring Project. She's also Faculty Associate at Harvard Berkman Klein Center. And Petra is the author, among several other researchers, of The World Have Eyes, Surviving Migration in the Age of Artificial Intelligence. So this is how we'll be proceeding this evening. Each of the authors will present for around 8-10 minutes, and then we will move into space for Q&A with the audience. So those who are joining online can already start posing their questions as the speaker intervene at any time during the WebEx. And please use the chat function, not the Q&A function. So thanks again to everyone for joining us to this important dialogue. And with that, now I'm pleased to hand over to Carolina Gotardo. Carolina, over to you.
Thank you so much, Carolina, and good evening to everyone here in the room accompanying us for the launch of this important report. And also good morning and good afternoon for those of you that are joining us online from different parts of the world. I'm very pleased to be here with my colleagues, and we have been looking forward to the launch of this report because of its implication. Caroline already described what we do at IDC. I just want to add that, our main mission is advocating against immigration detention and promoting alternatives. And we work in the different regions, and we work in a constructive and collaborative way with different actors, such as people with lived experience, civil society, governments, and UN agencies. And we have actually been spending a year or so working together to get this report ready with my colleagues, Antonella, Daniel, and Petra. And it's good that now we have the report that has a lot of interesting findings that you will be hearing today, but also a lot of implications in terms of rights of people on the move. I just want to explain where this idea came from. And the idea came from because we, as IDC, as a coalition working on this area, on detention, we were noticing trends with regards to the use of digital technologies in the area. And a lot of our members from different regions in the world were saying to us, this is happening in practice. So we then realized it's very important that we're doing something on this area. And it basically mainly because of advocacy purposes, because this is evolving very rapidly. And we, as an advocacy organization, that was our main kind of aim. But then for us, it was important to do some research and a mapping on what was going on in different parts. And then OICHR and Carolina actually organized a meeting here in Geneva where we were talking about technology in general, and migration and technology, and the implications of technology and migration. And at that meeting, Daniel and Petra were there. And we kind of later came together, and with the funding of the Robert Bosch Foundation, we were able to be where we are here and launch this report, which is the first stage of something bigger, because this will be followed by kind of advocacy. And it looks at the impacts of digital technology on immigration detention and alternatives to detention. When I was speaking about the global trends, I think it's important to put this in context. So we have seen that migration is one of the most politicized issues of our time. And we're seeing the criminalization of migration happening in different places around the world. And then detention, alongside other issues such as externalization of borders, pushbacks, and deportations, and the criminalization of solidarity is one of the symptoms of this criminalization of migration. So for us, other trends that we saw is the use of alternative places of detention. So for instance, the use of boats or barracks or isolated spaces or isolated locations, or police stations with regards to detention. And this was one of the very, very strong trends, the increased use of technology and surveillance in immigration detention. And I'm talking about that we're going to be touching on that GPS, electronic tagging, and monitoring, raising very serious human rights concerns. So if I move the slide. Here, as you can see, the promise versus the reality, as you could see there. So basically, some countries are promoting GPS monitoring and tracking apps as humane and cost-effective alternatives to detention. But in reality, what we're talking about when we're thinking about this type of surveillance technology is that it often replicates the very damaging impacts of detention, and it brings harms in new digital forms. And this is exactly what we're talking about here. But before that, I need to clarify what we mean by alternatives to detention. So at IDC, we have a very clear definition that is any law, policy, or practice by which persons are not detained for reasons related to their immigration status. So what I'm talking here about is that shifting that emphasis away from security, surveillance, control, and restrictions to a proactive and pragmatic approach that is looking more at case resolution, and that ultimately is based on supporting migrants and is based on case management And ultimately, it means that it could be a win-win for both migrants and governments. This is what we mean by alternatives to detention. And here, yeah, community-based, rights-based. In contrast, this approach is quite different. This approach is showing us that this surveillance technology is part of the migration enforcement network with limited transparency and without independent oversight. And without any type of consent. So Carolina already said the use of technologies in detention and ATD and in general in migration is not neutral. And this is important to clarify. So detention could be used to support migrants, and Petra will speak about that, or it could be used in negative and damaging ways. And evidence is very clear here, and it shows that electronic tagging and monitoring and this type of technology has very detrimental impact on the mental health and physical health of people, and it can lead to discrimination, and it can lead to stigmatization. I want to just share with you one quote that I think is very powerful, and it's a quote from Sam, who is a refugee in the UK, that is in our report, and it says, the quote says, "My world contracted, and my mental health went into freefall. I came to realize I wasn't really free. I was in an outside prison. The government knew where I was 24/7. And this is a person that had one of those electronic tags that we're talking about. So people also describe this experience as a type of torture and explain that they feel often on the edge with this use. So in that sense, the report considers this. The report considered this use of surveillance technology, such as electronic tagging and monitoring and smartphone-based tracking, within the detention and context, characterized as alternate forms of detention and not alternatives to detention. So some type of virtual detention, alternate forms of detention. And this is very important, and Daniel will explain this in a lot of detail with regards to the different types of technologies that we're seeing. Just to finish, and before we go into Daniel explaining this, I just want to explain how did we come to where we are with regards to the research, and where is that we got our information from. So we wanted to give this both global and understand the regional differences with regards to this. And you could see there in the slide that we actually had 58 participants across different regions of the world in 8 different consultations that we did. And our consultations took place in Africa, Asia, Australia and New Zealand, Europe, Latin America, North America, the Swana region, and a global consultation. So the different regions in the world, and what the consultations are showing is that some governments, particularly in the global north, are deploying this type of surveillance technologies, while other governments are considering using these technologies for further diffusion, and it's kind of expanding this model of surveillance. Like with regards to regional findings, and I'm not going to go in detail about this because you could read it in the report, there is a lot of detail there, but I mean, the United States has been the main country expanding the privatized surveillance technologies, such as this electronic tagging, smartphone-based tracking, and this is extending that control into communities under the guise of effectiveness and efficiency. So that's the United. This includes, for instance, biometric tracking, algorithmic monitoring, private sector partnerships, and there will be more about this because this is a very important. This is an element of how the model is functioning. So the immigration enforcement in the US is also being shifted into this digital world, or the digital realm, and is expanding these types of control and surveillance. In Europe, there is a growing preference for automated enforcement and for biometric verification of migration management in general, and also these type of partnerships that I was mentioning before with the private sector. And also many countries have detention facilities that are equipped with technology that increases surveillance. But in Europe, electronic tagging and monitoring happens less, but under the new return regulation proposals, they contemplate the use of this type of technologies there. But specifically, the country in Europe that is using this type of technologies already is the UK. And then in the UK, they have piloted one of the most expansive uses of electronic tagging and monitoring for certain asylum seekers that have been released from detention and that had to wear the ankle bracelets. And I already explained what this is doing. The interesting thing there is that in 2024, the High Court found in the UK that this use of electronic monitoring was unlawful because it didn't consider the individual circumstances and it didn't provide the analysis with regards to proportionality and necessity. So it's interesting what the courts are already saying that, about this in a country like the UK. Then we have Australia, where the participants, where there are technologically intensive systems in detention centers, and where we are seeing also the use of electronic tagging and monitoring with people being released from detention, from the ankle monitors, but also we are also seeing the use of drones for people released from detention. Just to finalize, in regions in the south, such as Africa, Asia, Latin America, and the Swana region, there is a scarce, until now there has been a scarce use of technology in the specific area of alternatives to detention, but there has been more use of technology for migration management in general, but not specifically on ATD. Examples, there is use of tech for detention or deportation, for example, in the Gulf countries or in countries in Asia. The use of technology is different, is more for technologies such as biometric registration, but we have to put this in context because this documentation and this type of use for documentation can be used for preventing a person to be in physical detention. So in that sense, this is important, but of course, there are concerns around, some of the consultation participants expressed concerns about data privacy and due process and all of that. So this needs to be considered when analyzing that. And specifically in Latin America, some countries are still not using detention in the same way. So some countries in Latin America are still hopeful for the rest of the world in terms of non-detention practice. I will leave it here, but I just want to finally emphasize what I said before, and it's the worrying about the expanding effects of the use of these digital technologies already in some countries in the north, and how many human rights implications they could have. And that's why we have these principles that my colleagues are going to be talking about, and I'll pass it back to Carolina so that we can go deeper into the different types of technology and the principles.
Carolina, thank you very much for grounding us on how the project began, some of the very interesting an overview of the global mapping, definitely something that we're not seeing as an isolated fact, but that is in all regions and expanding, and also for bringing the voices and testimonies that showcase the human rights impacts on the use of these technologies, and the important reminder, of course, that even if under the disguise of alternative, the surveillance technologies are restricting liberty and expanding detention. With that, then I'll give the floor to Daniel, who will unpack this further and bring us also into the guiding principles.
Thank you. I just want to begin by also thanking everyone attending in person and online. And I hope you can still hear me after that crackling. And also to say what a pleasure it's been collaborating with the IDC and the Refugee Law Lab on this project, and particularly recognize the incredible work the IDC did with the sort of really rich global mapping that provided so many interesting insights that sort of fed into the report. We were also joking before we started about our different expectations of timeframes. As an academic, turning this around in 1 year was like a record time for a project. I was like so proud that we managed to get it out in a year. And Carolina was saying, "Oh, this took so long. It took us a whole year to do this report." So I think it's kind of disconnected expectations, but really, really happy with how it ended up. And I hope it's the beginning of a much broader collaboration as we move on and talk about how we implement some of the findings. So one of the key contributions of the report is some of the work we did in, I guess, categorizing and mapping out the different types of technology that are being used in this space, and kind of recognizing that not all technology used in this space is equally intrusive, and depending on the design and impact on individual liberty, the risk factors can vary significantly. So we sort of had three broad categories. One is surveillance technology, and these are any tool that continuously monitors or tracks or records people's movements or behaviors without user initiation. And so these are tools like wearable ankle monitors or wristwatch electronic tracking devices, but also smartphone apps with live tracking capabilities. And as Carolina mentioned in her opening remarks, we characterize these not as alternatives to detention, but alternative forms of detention. The next category are digital reporting tools. So unlike surveillance tools, which continuously track an individual's movements, these require people to actively check in or provide updates or confirm compliance, often at scheduled intervals. And while these are generally less intrusive than surveillance, having unpredictable intervals for check-in, but also requiring the sharing of sensitive biometric information as part of the check-in process kind of changes the risk factors there and actually can make these tools also surveillance-like. And then finally, we have the digital, just in terms of examples of digital reporting tools, it varies from, again, smartphone apps, but again, just used specifically for checking in rather than constant tracking. But in this category also include more traditional forms of telephonic reporting as well. And then finally, we have the digital support services, and these are really designed to empower individuals within ATD programs rather than control them. And Petra will talk about some examples of this in the final section of the presentation today. So I think distinguishing between these different types of technology is quite important in terms of better evaluating their impact on rights and the risks they pose, and to advance truly rights-based alternatives to detention. And some of the key risks that we identify in the report include the potential profound impacts on human rights, including the risks to privacy, liberty, equality, and the right to health. And in the appendix of the report, we have kind of a comprehensive mapping of the various human rights implications of these technologies. Another risk, and again one that Carolina's touched on already, is the risk of expanding rather than reducing detention. And the risk here is that people who otherwise would have been released without conditions have conditions that amount to de facto detention imposed on them. Another core challenge lies in the lack of transparent decision-making criteria for imposing digital surveillance and reporting measures, which are often imposed as a result of blanket policies and without individualized risk assessments, as well as what is often absence of free and informed consent or opportunities to opt out from the use of the technology. And in terms of legal accountability and oversight, there are often no mechanisms available for people to challenge the imposition of surveillance and reporting measures. And where they do exist, a lack of transparency about how the technology operates, and the outsourcing to private companies act as significant barriers to individuals exercising these rights. And Antonella is going to unpack some of these risks, particularly in relation to privatization, more when I hand over to her in a moment. There's also the risk of datification and algorithmic discrimination. So as these surveillance and also some of the intrusive digital reporting tools expand, there is more and more data collected, often unnecessary data, raising acute privacy and consent concerns, and the inappropriate reusing of this data for other purposes. And then there's a risk that all this can get fed into algorithmic decision-making tools that determine the level of restrictions to be imposed, that introduce other risks related to bias, profiling, and discrimination. And so I've flagged the risk that come with privatization and profit, and again, Antonella will talk about that more in a moment. But just to round off this section here, it's important to emphasize that while digital surveillance may seem less invasive than incarceration, it can produce profound psychological and physical harms. And it can have serious impacts on health and well-being. And people who are subject to constant digital surveillance often report anxiety, fear of non-compliance, social isolation, and feelings of criminalization. So one of the key contributions of the report are these set of 10 guiding principles that we propose to guide the implementation of technology in this area. So these cover kind of all three of those tools that we identified earlier on: surveillance, digital reporting tools, as well as digital support tools. But I think it's important to emphasize at the outset that the surveillance tools will very rarely, if ever, meet the criteria set out in the guiding principles. And it's also important to note that these principles shouldn't be read in isolation, but all complement and build on one another. So I'm going to run through the first 5, and then I'm going to hand over to Antonella to run through the following 5. So the first one relates to prioritizing human rights. So technological tools used in alternative detention must be designed and implemented in full accordance with international human rights standards. They must prioritize the liberty, dignity, privacy, autonomy of individuals over coercion and surveillance. The second principle is designed to avoid de facto detention and requires that technological tools used in alternatives to detention must not amount to a deprivation of liberty, either individually or cumulatively, whether alongside other surveillance technologies, digital reporting tools, or non-tech compliance requirements. This would amount to de facto or alternate forms of detention. The third principle is targeted at addressing the risks that we've discussed at length already about the expansion of the detention net. And it requires that technological tools are only deployed in alternative to detention, where they enable people at risk of or in detention to live freely in the community. The use of technology should be non-intrusive and supportive, not punitive or coercive, and approaches that replicate or run parallel to existing immigration detention systems without helping to reduce the use of detention, or that impose continuous or unnecessary monitoring do not constitute true alternatives to detention. The fourth principle relates to fostering greater transparency in decision-making criteria and compliance with international law, and in particular international human rights law. And to that end, it's essential that technological tools that restrict liberty are only used where there is a clear and specific lawful basis to do so, and only when absolutely necessary, following a careful, individualized assessment of a person's circumstances. Such measures must be the least intrusive and most rights-compatible option, and never be applied as default or blanket solutions. And the fifth guiding principle relates to free and informed consent. It requires that participation in digital programs that restrict liberty should be based on free and informed consent, and that individuals must be fully informed about how digital technology tools work, what data is collected, how long data is stored, what alternatives are available, what rights exist to challenge decisions, and the ability to opt out of participating in digital programs. But also, importantly, individuals must not be penalized for making the choice to opt out. And I'll hand back over to you, Carolina, to continue the discussion. Thank you.
Thank you, Daniel. And again, for this very timely contribution with the guiding principles. As you said, they need to be read and implemented holistically all together. And so I will pass immediately to Antonella, who will run us through the remaining guiding principles.
Thank you, Carolina. I cannot see. Oh, it's already there. First of all, I want to thank again everyone for being here, and the Global Migration Center for hosting us, and everyone who contributed to this report. Just to reiterate, this is 158 people that are people with lived experience, researchers, academic advocates, and all sorts of experience that have informed this research. And one of the concerns that has been highlighted by pretty much every consultation in every region in different forms is the key role of the private sector. So as we said, and this is what the guiding principles build on what's been said so far, but I'm going to focus specifically on the lack of transparency of the system in the light of the significant role of the private sector in driving the process and building the infrastructure for this. So we said, digital surveillance and reporting programs lack independent oversight mechanism to monitor compliance with relevant human rights standards, as well as transparency around third-party contractors. The privatization of immigration enforcement in general and also in detention has extended from detention centers also into the digital sphere. It's a key feature of the system today. Where corporations are designing, co-designing with governments or independently designing, implementing and managing technological surveillance features that are used to restrict freedom of movement and are part of what are defined as alternatives to detention that we have described are not rights-based. And this is turning the monitoring of people on the move into a multi-billion-dollar industry, like a very lucrative business. And unlike public institutions, private corporations are driven by profitability rather than public interest. So this misalignment of values raises serious human rights concern. These companies very often don't have experience in the reality of migration. They have experience in prison and surveillance technologies, building digital enforcement structure, and outsourcing this to the private sector means also even less democratic oversight and public accountability. This infrastructure relies on extensive, increasing and often unnecessary data collection of biometric and geolocation data. This way creates a rush to datification of individuals and heightens the risk of mission creep. And to talk about the profitability, contracts often include per person payments, performance incentives, and occupancy quotas that undermine efforts to reduce detention because there is no incentive to do that, and dehumanize further people on the move. Creating a human rights vacuum in which people are exposed to surveillance and intrusive reporting requirements without legal clarity or recourse. This is why we are looking at the other principles that include the proportionate and access to review and oversight. Individuals subject to technologies that restrict liberty must have meaningful access to independent oversight and review mechanisms so they can challenge the imposition of restrictions and have access to legal recourse. This review process should assess whether the decision to restrict liberty was lawfully authorized and was both necessary and proportionate. It should involve specific consideration of the individual circumstances and vulnerabilities and of the potential harms of the restriction, including harm to family members. Measures must not only have a basis in law, but the grounding law must also be accessible, foreseeable, and sufficiently precise, and must provide safeguards against arbitrariness. Ongoing human rights monitoring should be institutionalized to evaluate the impacts and to mitigate the harms of digital tools for the entire life cycle of each tool's development and implementation. The seventh principle is data minimization and privacy, precisely to avoid the uncontrolled and unchecked data collection. So data collected must be strictly limited to what is necessary for a specified, legitimate, and lawful purpose. It must also be anonymized where possible and must be sourced securely, with people on the move having clear access rights and data control, as well as the right to erasure and the ability to opt out of data collection. Decisions that affect life, dignity, and well-being should not be driven by automated systems that are not accountable. And thinking of that, we also propose principle number 8, which is a moratorium on algorithmic risk assessment. A precautionary moratorium on algorithmic risk assessment for imposing surveillance technologies should be adopted unless and until demonstrable and ongoing safeguards can ensure transparency, accuracy, the absence of bias and discrimination, and accountability in their design and implementation. And we haven't been able to find any at the moment in the research we have conducted, spoiler alert. We're also going more deeper into the public interest over profitability, which is the ninth guiding principle. Any technology used in immigration detention, surveillance, or ATD should be developed, managed, and deployed by governments or NGOs as far as possible. Any outsourcing, whether to NGOs or commercial entities, must adhere to the principle of open and public procurement, be subject to ongoing human rights and data impact assessments, and include safeguards to ensure transparency and accountability. And public procurement, where contract remains shrouded in secrecy, actually offer an opportunity for transparency, including the release of information concerning whether the technology is a product or service of a private vendor. So if a private vendor is involved, details like intellectual property should be subject to scrutiny and accountability for all collected data. As said earlier, while digital surveillance might seem less invasive than incarceration, it produces psychological and social harms, and it adversely impacts people's physical health. And there's been already research studies that prove that in a very compelling way. This is why also the 10th principle is about engagement and non-enforcement. So technology used in the context of ATD should focus on enhancing community-based support, integration, and case resolution, and should respect rights. This means moving away from enforcement-focused surveillance that harms, stigmatizes, and criminalizes people on the move to engagement-based approach. Technology should empower individuals towards a just and fair resolution of their case by facilitating effective case management and holistic community-based support to help people achieve stability, navigate complex systems, and access services. Technology and evaluation processes should also be actively designed and co-designed with people on the move. It is crucial to reframe, just to sum it up, to reframe the focus of technology away from enforcement and surveillance and towards tools that facilitate engagement and generally support community-based integration. This shift requires centering the voices and experiences of people on the move and ensure that digital solutions empower rather than control and support rather than stigmatize. We hope that with this research we have been able to do that, and with that I hand over to Carolina. Thank you.
Antonella, thank you very much, and thanks to you and Daniel for explaining to us what are the key technologies, what are the impacts, what are the risks, and also going through the 10 guiding principles. I encourage you all to look at the document. There is also a very useful tool, I think, for advocacy purposes. They are summarized, the guiding principle, in a couple of pages, which are extremely helpful for the work that we're all advancing. And then to close the presentations, of course, Petra, over to you.
Thank you so much, Carolina, and thank you to all of you for being here. We wanted to close this conversation on a more forward-looking, positive note, just as we do with the report. The situation is difficult. Much of the technology, as my colleagues already talked about, is infringing on the rights of people on the move, but there are also opportunities for us to move from these principles to practice and rethink the role of technologies in alternatives to detention. So the last section of our report looks at different types of digital support technologies and also some of the principles and ideas that underpin how different types of tools can be designed with and for people on the move and affected communities. Because when tools are designed and deployed within a rights-based framework and a community-based framework, technologies can actually serve as facilitators for empowerment rather than control. So this is also an opportunity for us to do a broader rethink of what technologies can actually do for mobile communities. It is in fact a reorientation though, because instead of looking at technologies as a way to enforce compliance, we need to think of trust as a central idea when we design these types of technologies in order to enhance access to legal and other support services and to support the well-being of people on the move. Indeed, we go as far as to say that technologies must be embedded in a broader ecosystem of care, underpinned by transparency and community of detention versus surveillance. Instead, focus has to be on leveraging digital support tools to foster justice, empowerment, inclusion, and integration as part of community-centered, rights-based alternatives to detention. So one of the classes of technologies we look at in the report are what we call technologies that enhance access to legal advice and information. We know that one of the most transformative applications of technology in the context of ATD is its capacity to enable informed and meaningful participation for mobile communities in immigration and asylum processes. People on the move are already navigating very unfamiliar legal systems, sometimes in different languages, limited literacy, and digital exclusion. And these communities are particularly vulnerable to missing critical deadlines or misunderstanding obligations in these systems. And legal representation is often one of the, if not the strongest predictor of success for case outcomes for people on the move. Yet, many people on the move face structural barriers in order to secure legal representation. We found in our report that technology can play a transformative role in facilitating access to legal services and information as well. Tools like secure video conferencing platforms, online scheduling tools, encrypted document sharing systems. These are just some of the examples that are already being deployed to bridge the gap between people on the move and legal service providers. There's also some really interesting grounded examples that we draw on, for example, legal kiosks that are being deployed in Mexico along the Mexico-US border, and different types of apps that are designed by and for mobile communities themselves. But of course, there are also issues with data protection, and also the need to grapple with persistent digital divides, the fact that mobile communities oftentimes lack access to Wi-Fi, reliable internet connectivity, smartphone hardware, and other types of problems. However, we believe, and as our report also shows, when thoughtfully implemented, technologies that actually facilitate access to legal advice and information can be instrumental in building trust in the system as a whole, safeguard due process, and promote just outcomes for people on the move that are navigating very complex immigration and detention regimes. The second area we explore are technologies that enhance case management and access to support services more broadly. Again, these are community-based programs that prioritize dignity, empowerment, individualized support, and other types of assistive tools that are necessary for people to thrive in the system as it is. But again, this is also an invitation for a broader rethinking, where people on the move are treated not as enforcement targets, but as rights-bearing individuals that are navigating incredibly complex migration systems. So again, it's a move away from enforcement, but rather towards a rights-bearing paradigm. And in this framework, case management, which includes ongoing assessments, legal orientation, assessment, referrals, trust relationships, access to services, and also psychosocial support, can be enhanced by technology. But again, what we really try and drill down to is that no matter what the tool is, digital tools can never replace human relationships. As our consultation participants repeatedly emphasized, the success of any community-based ATD, whether in person or whether supported by tools and technologies, must always hinge on trust, casework, cultural competence, and also individualized screening and assessment. So technologies in and of themselves are not a panacea, but rather they're an assistive tool. And when we prioritize user-centered design, multilingual platforms and accessibility, and also inclusive data practices, these are the things that ensure that whatever is developed is actually serving the needs of affected communities and people on the move, and that these systems strengthen, not displace, the kind of relational fabric that needs to be at the center of these supportive networks. And when done right, digital tools in the context of alternatives to detention actually play a pivotal role in fostering stability, empowerment, and long-term integration for mobile communities. Again, people on the move are not risks to be managed, but rather they are agents who are capable of also building meaningful lives and contributing to their communities when supported properly. And when alternative to detention programs include technologies, they help shift the paradigm from punitive oversight to a human-centered, rights-based, and opportunity-driven model of migration governance. And last but not least, we also explore technologies that are participatory and designed by and for affected communities themselves. Because any types of rights-respecting technologies hinges on the development through participation. Rather than imposing top-down solutions, participatory design invites us to think about who is actually in the room when tools are designed and what counts as expertise when we innovate. And when we have affected communities who are the builders and thinkers and innovators and who are imagining what kind of world we can build, that's when we see technologies that actually reflect the lived realities, languages, risks, preferences, and also opportunities of people on the move. So again, there's a huge opportunity here to actually involve people on the move with lived experience of detention and displacement in the participatory design processes of technologies themselves. This also invites us to perhaps do a better job of engaging with tech workers and people who are actively creating these technologies as co-creators rather than the ultimate experts, because we believe that there's a lot of expertise that is grounded and held by lived experience communities themselves. And again, this approach challenges this kind of top-down imposition of what counts as innovation and what counts as technology. Because when communities are empowered to build and adapt and also reject technologies, digital interventions are actually the ones that make it into the communities, are more likely to support dignity, autonomy, rights, access to pathways, and long-term integration, the very goals that ITD programs are actually meant to advance. I'll turn it over back to Carolina.
Petra, thank you so much for that important reminder, in particular that designing solutions together with affected individuals and communities is key. Before I open the floor for questions, let me just quickly hand back to Carolina, who will run us a bit on the next steps and opportunities.
Yeah, thank you, Carolina, and thanks to the lovely panelists that I have here that we have been working together all this time to get into this report. As I mentioned before, for us, we always saw this report as the first stage of something much more important, which is advocacy, because of course a report and a mapping that stays there is not going to do anything. And we are seeing where the trends are, and it's important to focus on the advocacy. So for us, this is going to be the second stage. And we're also planning to have regional conversations on this with different stakeholders and start that whole new phase on advocacy. So, I mean, just to leave it here, this is an invitation to all of you that if you're interested on this topic and interested in continue engaging in this important conversation, you can see our details there. And I also an invitation for you to look at the report and send us your questions or your comments on whatever it is before we start this second phase. And I'll pass it on back to Carolina.
Great, thank you for that, Carolina. So we'll open up now for questions. So this is how we'll go about this in the room. If there are any questions, please raise your hand. We will be bringing the microphone to you. Do please introduce yourself and use the mic close so that colleagues that are joining online, we have several participants, can follow you. And all those that are online, we already have one question so that they can continue sharing some of their thoughts in the chat function, please.
Hi, this is on, yes? Yes. Michael Flynn, I'm with the Global Detention Project based here in Geneva. First of all, thank you for this amazing work. I'm looking forward to exploring the report. I'm also keen to see if Daniel has put some of his expertise in diffusion into his analysis of how these alternative forms of detention are spreading around the world, and to what extent there are legal ways to combat it rather than humanitarian ways. I want to play devil's advocate a little bit. I hope you don't mind. And partly, I want to talk a little bit about what I see as some definitional issues that I'm a little bit confused about. I'm confused about the use of the word detention. I'm confused about the use and definition of alternative to detention. And I'm also confused a little bit about the guiding principles. And at the heart of my pushback, a little bit, slightly, is the idea that we could potentially all agree on any system of alternative to detention that does not lead to less people in detention is a form of surveillance, an expanding surveillance web. And if that is the case, it seems to me that what we see here with tech using this is simply an affect of what alternatives to detention already are if they aren't leading to less detention. And I'd be curious to know if whether or not that is a foundational principle we can agree on here. Because What we see in the data that we've developed at the Global Detention Project is that no matter what terms you use or what tech or forms of ATDs you use, we see them expanding, and we see detention expanding at the same time, which means that more and more people are being placed under forms of surveillance, whether or not they're more or less onerous is a question. So that's one issue. The second issue is detention and the idea of things being alternate or alternative forms of detention, whereas I think I'm accurate in saying it's legally not accurate to say this, because I think detention, properly speaking, is deprivation of liberty, okay? And deprivation of liberty can be seen on either on a sliding scale or on a slippery slope, or well-defined as being unable to leave a place, right? Or unable to leave if an arresting officer has taken you and has detained you and doesn't let you leave. Those, I think we can find some things to agree on. But whereas alternative to detention that you're talking about here, I don't see that this is actually an alternative form of detention. It's actually alternate. They are alternative to detention, definitionally speaking, even if we want them to be in a better way. So thank you very much, and congratulations on the report.
Thank you. And yes, we're getting a number of very encouraging messages in the chat, congratulating all the drafters. I think we have another question here, Isabella. And
there was another question over there.
Okay. I encourage you just to, very briefly, we don't have a lot of time to introduce yourselves.
Thank you, and thank you to the panelists and sharing fabulous research. And I love it, Carolina, that you said this is just the beginning. Fabulous. I'm an alumni here. I've just completed a master's here, and my particular research interest is child rights, and that's been my work background. I co-lead a working group under the Global Family Reunification Network, looking at family reunification as a protection solution for unaccompanied and separated children. So my interest is around children and detention, and I'm really interested in, and my apologies, I did come in late, so this may have been covered, but was there any insights through the research on particular demographics and any insights into how this surveillance is impacting on children in detention? And there's a lot of work being done around alternatives to detention for children. There's a particular child rights framework under the Convention on the Rights of the Child and others. I'm particularly interested in whether that came through the research. Any other insights? Thank you.
Great. Well, we'll get the mic to Isabella. Let me just share one of the questions in the chat. So we have a colleague asking whether there's current data on technology vendors, and in particular, if these have changed in the last years. Do we see any trends in terms of who sells what to whom in the space of surveillance tech? So I'll give the floor briefly back to you, but let's first hear from Isabel. Over to you.
Thank you. Thank you very much for very interesting report and very interesting presentations. I'm Isabella Meijer. I'm an independent consultant. I have actually two short questions. First one about the principle 5 about consent and the fact that a person should not be penalized. So I'm just curious how to apply it in practice. Does it mean that if a person refuses application of electronic tools on him or her, does it mean that the person will be just placed back to detention? Or, yeah, just curious about the non-penalization and informed consent. And second question, maybe a slightly broader, in the European, in the EU context with the proposal of the return regulation that Carolina mentioned, Article 33, which provides so-called alternatives to detention. I don't know whether you as IDC would qualify them as alternatives to detention or not, but there's a measure that can be applied instead or after detention. So if the person otherwise should be detained, or if the person should be released, or if the person shouldn't be detained at all. So first of all, I don't know whether this measure would be qualified by you as alternatives to detention, but there's actually a more important question in the current discussion. The Article 33 lists various measures, including, broadly speaking, electronic monitoring. So are you looking at this question, would this measure pass the test, or how the guiding principle would apply to it, or does it become to the first or the second category that you provided? Thank you very much.
Thanks to you. A lot to unpack. We only have a few minutes, but I hope that at least we can start some reflections. I won't indicate who will speak. I'll let the colleagues decide, but I know Carolina already have some reflections on the various points shared.
Yeah, thank you very much. I can get back to Mike and to Isabella and reflect a little bit on what Nadine said. And my colleagues, I'm sure, will reply to the other questions and elaborate on this. With regards to your point, Mike, and I don't think this is the first time we're speaking about definitional issues. I think we have been speaking about this for many years, I would say. The first thing to say is that detention is indeed expanding, and we know that. I mean, we keep saying that all the time. The second thing to say is that, again, there is no legal definition on alternatives to detention. That doesn't exist. There is no legal definition. So for this report, the definition on alternatives to detention that we're using is the definition of IDC, which is the one that I was sharing with you before, which refers to community-based rights-based alternatives to detention. And then probably the next thing to say is that, yes, we know that detention is expanding, but we also, IDC has published already a number of cases where alternatives to detention are working in different parts of the world. So we don't necessarily agree with the premise that you're saying because we are departing from a different point, but we are, and we have spoken also before about the fact that for us, alternatives to detention are an advocacy tool towards non-detention approaches. And this is where an organization like IDC departs from. So the whole kind of definitional part is based on those premises and is based on the fact that there is no real legal definition. So of course we're departing from that point of view. Looking at, with regards to Nadine, with regards to, I don't think we did a specific demographic analysis, but and in the consultations we didn't have that demographic analysis, but for us, and you will find this in the report, the very, very strong positioning on what we all know that is international law, and is that no child should be ever detained because it's against their best interest and it's a form of violence against children. So you will see that you will see all of that all across the report. And then with regards to Isabella and her second question, which is probably the one I can answer. Yes, there is that proposal in the written regulation. So for IDC, just being clear about it, the use of electronic tagging and monitoring is an alternate form of detention, not an alternative to detention, and our positioning is clear. And for those members of states that might be looking at this online and that we're engaging with, because we're engaging with quite a number in Europe very constructively, we will love to continue having conversations on this, because these are alternate forms of detention, not alternatives to detention. And it's important that we understand that in terms of how do we go forward, because otherwise we're just going down rather than up in terms of standards. Yeah.
Thank you, Carolina. You covered quite a lot there. I'm looking at the other panelists to see whether they want to complement. Yes.
Maybe I'll briefly touch on Michael. It's a great question. I think the first point, diffusion, which is the one I'm most excited to talk about, as you know my interest, the Dorothy Dixer question. I think it's something I'd love to look into more, because there's particularly the role of the sort of private companies in reaching out and being the actors of these tools spreading around the world. But it's not something we look at specifically in this report. I think you raised some interesting points around definitional issues. I'm really happy to chat about them afterwards. I think in terms of legal definitions, we're not really putting forward legal definitions here. I think with alternatives to detention doesn't have a strict legal definition. I think we're defining it in a way that we think makes most sense. And when we say that the sort of surveillance tools or alternative forms of detention, that's not necessarily in a legal sense, but as a distinction from alternatives to detention, which we define, and they clearly don't meet our definition of alternatives to detention. I don't know, there was a few questions about sort of the private contract and so on. Anton, do you want to touch on some of them? There was one on so the tech vendors and how they're evolving?
Yes. So in the report, we don't go too in depth, like as a comprehensive study on private companies. We look at we look by region and we look at examples. We explain examples, and for instance, we show how in some cases risk assessment tool are being co-designed. We mention contracts. We mention also the per person cost of vendors. So we're seeing an increase, and this is something that we have observed in consultation, and this is something that has emerged, like the increased number. There are other studies that have been looking more deeply into the financial depth of data vendors, and it's increasing. And there is also, I mean, we see also a lot of reporting, especially coming from the United States, of companies and how they are basically building like an infrastructure and getting to different databases to, for instance, to inform the work of ICE. Also going, again, this is something that's been mentioned before, how this goes into communities for undocumented migrants, as well as for people that regularly live in the United States. So this is also to show, like, this is, we have focused here on alternatives to detention, but of course this is something that goes way beyond this area. So yeah, this is to answer. But there are some examples in the report, but we don't focus extensively on the numbers and on the financial aspect of it.
Thank you very much, everyone. I think we covered quite a lot in a limited time frame, running through the mapping of how technology is being used, the understanding of the risk, setting out the key guiding principles, and then the opportunities for more inclusive and empowering approaches. I invite you all to read and engage with the findings and recommendations, and particularly with the guiding principles of the report. You have the QR code. There were a number of questions popping up in the chat box. We don't have time, but please do engage with the authors. Maybe I'll just take the opportunity to share some of my 3 takeaways after reading the report and this conversation. First, technology in alternatives to detention must begin and end with protection of liberty and dignity. Anything less risks reproducing detention in another form. Second, proposed safeguards are not optional. Oversight, privacy, accountability, transparency are what turn those principles into real protection. And then thirdly, the engagement and empowerment being key, including the co-design with affected communities, which is essential for the technology to support inclusion rather than exclusion. I just want to, before closing, thank the Graduate Institute for hosting us, in particular the Global Migration Center, and a warm thank you to Professor Vincent Chetai, and the Robert Bosch Foundation for the support to this important project, and particularly to you all here in Geneva, joining us online for joining this very timely conversation, and I'm certain that colleagues will be following up for the next steps that have been outlined by the panelists. So thank you very much, and wishing you all a good evening.